Good morning and welcome to our Coffee Health Industry Seminar Series. This is a special edition series today. Unlike our usual 1-hour sessions, we are running for an hour and a half until 9:30 with you this morning on the topic of the COVID-19 expert panel, key considerations for resumption of healthcare services. I'm Karima Kanani, a partner in our health industry group. And I'm joined today by my colleagues and partners, Catherine Frelick, also from our health industry group, a health regulatory and privacy expert, Hugh Dyer from our labor and employment group, and Rob England, our resident occupational health and safety expert. Before we dive into the material today, I just want to cover a few housekeeping items with everyone. We do have a significant number of individuals joining us today. All of your lines have been automatically muted when you join the session today. We kindly request that you leave your lines muted throughout the session so that there isn't feedback for the rest of your colleagues and everyone can hear the session clearly. The second tech feature is that we have in fact turned off the chat box for today's webinar session. Given the amount of material that we have to cover and the number of participants, it won't be feasible to hold a Q&A session at the end of today's webinar. So the chat box feature is turned off, but we of course always welcome your questions and your comments, and you're welcome to reach out to any members of the panel today. Everyone's contact information is contained on the first slide, and the full slide deck with audio will be made available to all of you after the session. Last caveat that I'd like to share with everyone before we get into our agenda is that we do have a very diverse audience today. So from a number of you that come from public hospitals across the province to others of you that are running independent primary care or other regulated health professional clinic and health services. So as we move through the material today, it is intentional that we are attempting to make it accessible to all of you as providers. And there may be some material that is more relevant to some of you than others. But if you can just keep in mind the diversity that we have here today, then you'll have an appreciation for covering the material in the manner that we are. So what is our agenda for hour and a half that we have together today? We're going to start with a bit of a recap on the facts. COVID-19 restrictions, what is the current status? What has actually happened in the province so far? Where are we sitting currently? And why are we having this conversation about resumption of healthcare services today? Then, for the large majority of our time together, I'm going to turn it over to our expert panel. And each panelist is going to walk through a series of questions that is going to give you a highlight of some of the key issues and action items that you can undertake in these various areas of law that are really the foundation of workplace resumption planning. And last, but certainly not least, we'll round off our discussion by talking about the Service Resumption Plan and how you take all of the information that is conveyed to you today and wrap that into the components of what you would put in your service resumption plan and the risk considerations that you should have in mind as you move forward. So where are we now? A lot has happened in the province. It was in March, which seems for most of us now like a lifetime ago, that they declared a global pandemic by the World Health Organization for COVID-19. And as a result of that and it arriving in our country, the government began to invoke certain powers that it always had, but that we rarely see them actively exercise in the way that we are watching this occur now. There are two kind of streams of legislation through which they've invoked these powers: the Health Protection and Promotion Act and the Emergency Management and Civil Protection Act. And I won't dive into the details of each of those acts with you today. Catherine's also going to talk about the regulatory key considerations that derive from these acts and how they operate. But I raise them with you here because it's under those pieces of legislation that, in fact, on March 17th, Ontario declared an emergency. And that's really important because once they declared that emergency in March, they were then able to begin issuing a number of provincial orders. And those orders, there are several of them now, some of which we're going to talk about today, have been how they've taken measures as a government to be able to control the spread of COVID-19 and to direct, to some extent, what we can and cannot do in respect of health services. In fact, there was an order made under the Emergency Management Act for the closure of all non-essential businesses. And in that order, it was almost written as one by exclusion. And so what was included as a schedule were the list of essential businesses. And if you weren't on that list, you were closed. And there were an extensive number of businesses on that list, including many health services, which were reduced, especially for regulated health professionals, to urgent services only. As this was occurring under the emergency legislation, under the health protection legislation, directives and orders were beginning to issue as well. And the Chief Medical Officer of Health, under the Health Protection and Promotion Act on March 19th, released what was called Directive Number 2. Fancy name, right? Directive Number 2 for healthcare providers. And what it provided was that regulated health professionals or persons operating group practices of regulated health professionals had to cease or reduce to minimal levels all non-essential and elective services until further notice. There were no definitions of what constituted essential services, and for many organizations and providers, that meant you needed to determine what would constitute an urgent or essential service that you would make available in these circumstances. And I this context for you today because it is due to this ramping down of essential service in the province, in our health services, that we're talking now about the ramping up or resumption of those health services. And that was in fact triggered by the framework for reopening our province that the government introduced in April 27th. Now that's just a framework. We haven't actually begun at that time opening the province. It was here as the blueprint of the different stages that we're going to proceed through in order to reopen the province. Following that, on May 14th, they began to announce what would constitute stage 1 of that framework for reopening, and included in stage 1 was the lifting of restrictions on in-person services delivered by health professionals. Now, we just talked about the fact that the restriction on these services, and the reason we're having these resumption discussions, is because of how they use the orders both under the Emergency Act around essential business and under the Health Protection Act around the direction on ramping down to essential service only. And so while they announced this plan on May 14th, there was still more work to be done before they can actually resume service in the province. So we are still awaiting an updated Directive Number 2, and Catherine's going to talk about some of the implications of that. And what is important to know is that it is in development. So we do know that at the central command table for COVID-19, that there have been discussions that have been continuing around the development of what this is going to look like going forward. We don't know what that is at this time, and it might not be as, and likely not be, as simple as we're now lifting the restriction and you can deliver services as you please, but there will likely be some conditions that you will have to follow and that may be attached, that may be included in that directive. So this will be a wait and see component. They have moved forward with updating the essential businesses list. So this was done under the Emergency Act. We talked about that a minute ago, of how they reduced it down to urgent services for regulated health professionals. So this is the full list of businesses as currently written that are under the healthcare banner in the essential business list that are able to deliver service, going, of course, hand in hand with any of the directives from a Health Protection and Promotion Act perspective. So how do we resume? Have they, in fact, put out any requirements yet of what you need to follow in order to resume services and health services in the province? Well, they've begun to do a little bit of that. We're beginning to see some of that begin to occur to guide planning. And the first of that was specific to public hospitals as they were looking at a measured approach to planning for surgeries and procedures. What it identified was several criteria that had to be met in order to reintroduce and prioritize the scheduling of surgical and procedural work. And of course, we know there are thousands of Ontarians that are awaiting care and that have had their procedures delayed due to the full human resource commitment that the emergency stage of COVID-19 required. So the purpose of these measures is to set out how they can recommence the delivery of services and procedures with these individuals. It does articulate certain expectations, not a comprehensive list, but they're around capacity that you need to maintain. Interestingly, they indicate specifically no hallway healthcare, which is a great throwback to what seems like our previous life, talking about health system transformation in this province and the reduction of hallway healthcare. And so that will be an important challenge I'm going to talk to you about today, as well as requirements for stock of PPE and other supplies, availability of HR, and as well occupational health and safety requirements. And so this is going to tie directly to the legal underpinnings that you're going to hear about from both Hugh and Rob in their respective areas of expertise today. Ultimately, the plan developed here is not one that is of your own volition as a public hospital. Of course, you need to approve it as a hospital. It's your plan, but so does the regional table. So there is an oversight mechanism here around planning. A variety of other guidelines that don't come as of yet with an oversight mechanism. That remains to be seen if that will be introduced over time here. But there are several guidelines that have been released by Public Services Health and Safety Association, and they also get into, in these guidelines, the purpose of them is how to resume service. What are the things that you should do or to resume service? We could spend an entire webinar just going through all these various guidelines and what their requirements are. But in general, they cover some consistent topics, as you would expect, across all of these various guidelines that are being introduced. Things like physical distancing, environmental cleaning and disinfection, hygiene, the reporting of symptoms and illnesses, statutory reporting requirements, and use of PPE. So a lot of consistent themes that you'll find across these guidelines. You would need to look through the guidelines list for those that apply to you, right? Appreciating that we have a diverse group participating with us today. There are different elements of those guidelines that are going to apply to different organizations across the continuum of care. For those that don't find a guideline that's directly applicable to what you do, there may still be more guidelines forthcoming, but that doesn't use what is out there around resumption planning to inform your work. All of those principles are still going to apply because as we see what they generally cover, these topics are topics of general application, and these are guidelines to help you along the road of resumption. There's one more source of guidelines that has begun to develop in the province, and that is coming from the regulated health professional colleges that have also begun to release some guidelines. Those, although called guidelines, can be more prescriptive. about what you must do in order to open your doors. Now, at this time, there are a handful of colleges that have released their guidelines. One could expect that there would be more, but I would note for you that some of the other jurisdictions in the country are a little further along than we are with this opening process. And so they can be informative about what we might see happen here in Ontario. In Alberta, in fact, they have directed and mandated that every college must have some guidelines. And if they don't, that they must then endorse or meet all of various safety requirements that have been set out within some of the Alberta orders. And so we might, as we see directive number 2 become updated, see something similar here in Ontario. And that really takes us through the background of why we're talking about work resumption today, how it came to be that services were ramped down or brought back, and how they're slowly being asked to resume in the province, and what planning or direction on planning has occurred to date. Now, what is clearly apparent from what they have released to date in terms of directions to resume and in terms of the circumstances that organizations have found themselves under when closing their doors from an HR perspective, for example, in dealing with layoffs and management of your workforce, legal obligations that you have are going to really be the foundation and underpinning of this resumption planning. And so while you may look at these guidelines and other requirements as they set and chart the course of some of the things you need to have your eyes on, that alone is not enough in order for you to complete your planning. You really do need to have a solid understanding of the legal implications of the various aspects of the plan and what you may be looking to implement across your organization. So our goal today is to spend some time with you and our expert panel to do a bit of a deeper dive into 3 key legal areas that will need to inform your resumption planning work. These include health regulatory and privacy, labor employment, and occupational and safety. So we'll start off our expert panel today with my partner in our health industry practice and our health regulatory and privacy expert, Catherine Frellet. Catherine, our first question for you today is, what are the top 3 issues from a health regulatory and privacy perspective for in-person service resumption amid COVID-19?
Thank you, Karima, and good morning, everyone. I think the number one key issue, and it was pretty evident just from Karima's opening remarks, is really relates to regulatory and privacy compliance. Karima touched on a number of pieces of legislation and emergency orders and public health orders and directives that are in place. As you know, there are multiple emergency orders that have been issued under the emergency management legislation, as well as public health orders and directives, both at the local level, as well as the 5 directives that have been issued by the Chief Medical Officer of Health. In addition, there are Ministry and Ontario Health directions and memoranda that have been circulated. There are infection control practices and guidelines, and all of these things are changing very frequently. So just keeping on top of everything that is happening, and ensuring that you're aware of the guidelines, legislation, and regulation and orders that are applicable to you. It feels like a full-time job right now for some of us, and it really is important to look at those as they change over time, because we're not in a static situation, and the advice now is based on what our current priorities are, which will shift through the course of this pandemic. So right now, much of the focus is on the long-term care and seniors care, congregate care types of environments. That will shift over time, presumably, as we see changes in the course of this crisis. There is multi-level government involvement, which is really important as well, because there are directions coming from municipal governments, federal government, as well as the provincial government, and they all interact and intersect together. And all of these will inform your internal COVID-19 policies and procedures, your resumption plan. They also inform the standard of care that would be applicable to an organization in the case that there is a lawsuit where negligence is based on a deviation from the standard of care. And so ensuring that you have identified the relevant guidelines that are industry-wide is very key to being able to demonstrate and establish that you have met a reasonable standard of care, as well as your corporate governance obligations. From a compliance perspective, there are many attestations that health service providers need to be able to provide to the ministry in exchange for the funding that they receive. And this is all part of that basket. Regulatory compliance also relates to privacy compliance, and we have seen a great number of amendments that have happened to the Personal Health Information Protection Act, as well as other privacy statutes. A number of them relate to health transformation and the movement to digital health and digital health planning, including, as well as COVID-19, including Bill 188, which is parts of which are now in force, which amended, among other statutes, the Personal Health Information Protection Act. Some of the key highlights for today are some of the expanded order and enforcement authorities that are now in force today relating to PHIPAA. There's the ability for a court to make a production order where there is a concern about a non-compliance with the Personal Health Information Protection Act, to produce documents and information. It may include looking at personal health information. Administrative penalties. This is a new enforcement mechanism where there can be fines that are imposed against a health information custodian relating to non-compliance with PHIPAA as well. And those are really based on both on deterrence as well as ensuring that there is an understanding that there are consequences to being non-compliant with the Act. And then finally, there are increased penalties for offenses under PHIPAA, with fines being doubled. And as you will recall, they were doubled fairly recently in the last few years. So they've been doubled again. So for a corporation, they can be subject to a fine of up to $1 million for an offense if upon conviction under the offense provisions. And for an individual, they can be fined to up to $200,000, and they may also be subject to a term of imprisonment of not more than 1 year. So that is a brand new enforcement mechanism that is now available in the event that there's an offense under PHEPA. And finally, there are a number of amendments that have been made relating to electronic health records and digital health interoperability, which are not yet in force, pending the delivery of regulations. So there's now a consultation process taking place with proposed amendments to the regulation to support those changes. The second key issue that I've identified are considerations for the delivery of safe client-patient care. There's no turning back. Even if we wanted to, we are not able to go back to a pre-COVID-19 model. And it's very clear that whatever we do going forward, it will have to be a hybrid of inpatient care and virtual care, as well as collaborative and innovative service delivery models. So they say that necessity is the mother of invention, and we've certainly seen that in the types of collaborations that that are occurring all over the province. And some of those are possible because of the removal of legislative, financial, and other barriers through the issuance of emergency orders and approval processes that have been put in place to enable organizations to more quickly enter into different types of arrangements than they have in the past. There was definitely a focus on digital health with the health service transformation agenda. And I would say that COVID-19 has really been a catalyst for virtual care services and options. It's very clear that we need to use our resources differently. And the other thing that's become very evident are some of the system breakdowns that are apparent with current models, and we need to be able to do things better, as well as consumer demand for services like virtual care that are convenient for the consumer and which they will want to see going forward. And of course, all of these various aspects do raise various health, regulatory, and privacy legal risks. The final issue, key issue that I wanted to focus on, and it may sound counterintuitive, but is planning for COVID-19 resurgence. So even though we are planning for the resumption of services, we really do need to keep in mind that this will likely be a lengthy process, and we still need to be prepared for future resurgence of COVID-19. And that means having contingency plans in place, having flexibility, both for the use of space as well as other resources, including human resources, and keeping in mind that emergency orders and directives are by their very nature time limited. And so they are only in place for a certain amount of time. And once they are gone or are no longer in effect, we'll have to look at other ways to deliver the care, or revert back to other types of service delivery models.
Those are some really important key issues from a health and regulatory perspective. What are immediate action items that must be taken prior to in-person service resumption?
There are a number of immediate action items. Karima mentioned the measured approach to planning for surgeries and procedures. And although it is focused on primarily to public hospitals and the resumption of surgeries and procedures, it really does require a systems approach. If you look at some of the key requirements that are needed in order to resume, it also includes things like the availability of post-acute care outside the hospital that would be required to support patients after discharge. So it's not only having a stable number of COVID-19 cases, having a stable supply of PPE and medications. There's a need to look at all of the system impacts, and in fact, having adequate capacity in the hospital will very much depend on the flow through of patient care and the ability to provide services to patients outside the hospital environment. And so one of the requirements for hospitals is that they reserve 15% of acute care capacity. And one of the things that we're seeing is that with the moratorium on discharging patients to some of the long-term care environments, that hospitals are now building up their ALC populations, which then impacts on their acute care capacity. So, as I said, it's very much a systems perspective. Even though some of the emergency orders, including the essential businesses emergency order, has removed restrictions for regulated health professionals, and so it no longer is restricted to urgent care. As Karima mentioned, until the directive is in place, directive number 2 with the changes, the restrictions on non-essential and elective services continue. So my immediate action item for this, in this regard, is to hold off on immediate action, continue to plan for the resumption of service, but we're not quite ready to go ahead yet. Review health regulatory college requirements. So there is a lot of variation amongst the colleges about how directive they are to members. The College of Physicians and Surgeons very much relies on a professional judgment type of model, whereas there are others that are extremely prescriptive in terms of what their members must do and what they must have in place before they resume services. And they also have different interpretations of and directives. So they may be based on the type of services. They may be based on their acceptance of virtual modalities in telepractice. Some colleges are have used those types of modalities for many years, and others not so much. And just for an example, one of the colleges that have come out is the Royal College of Dental Surgeons of Ontario, and they have a 3-staged approach for the provision of in-person care during COVID. And the stages will fluctuate, and I thought this was really interesting because it is a fluid model. There are 3 stages where there's heightened community transmission. In-person care is restricted to emergency or urgent care. As community transmission declines, there will be an expanded list of in-person services with enhanced precautions, and that's where we are now. It's stage 2. And then finally, they have stage 3, where the community transmission is significantly mitigated, and there's a new normal where we're providing in-person care with reduced precautions.
Well, we all hope that we reach stage 3 as quickly as possible. But in the meantime, as we work towards planning, what tips can you provide for organizations to mitigate the risks of delivering in-person services?
So there are a number of tips for risk reduction. One of them being compliance monitoring and having a process to review, to disseminate information to the right people within the organization, to be updating your policies and procedures to ensure the resumption of in-person services comply with laws and as they change over time. Having an internal and external communications plan so your employees, clients, and patients understand what the changes are, what services you're providing, and what the workflows are as they change over time, because they will change over time. Ensuring necessary training and monitoring for employee compliance with those processes. It's absolutely critical to have employee and client screening protocols in place for as well as for visitors and infection control and physical distancing measures. Looking at conservation and preservation of PPE. So that is an ongoing issue that we're facing across globally. And so we need to ensure that we have responsible use of those resources and are continually sourcing PPE and equipment through various sources and documenting those attempts as we go through. And then finally, looking for efficiencies and opportunities to reduce in-person time. Can we design our services differently so we have pre-registration processes, we can do virtual assessments and triaging, e-consultations, remote monitoring, incorporating all of those different things into our model of care. With all of the collaborative care that we're seeing, one of the most important risk mitigation recommendations is to ensure that you have appropriate contractual agreements between parties which set out their roles, so there's clear roles and responsibilities. You've addressed risk allocation, you address insurance, and there's an ability to exit, particularly where that collaboration is based on a temporary emergency order. There are, with the advent of virtual care modalities, it's never been more important to ensure the privacy and security of our technology platforms. Health organizations are unfortunately very much the target of cybercrime and cyber criminals, including ransomware. So it's no time to skimp on doing proper privacy impact assessments and threat risk assessments, ensuring that you have all of the necessary policies and procedures and processes in place, particularly now with the more significant penalties that are available under PFO. And then by definition, as I said, emergency orders are time limited. So having the ability to exit arrangements as necessary. Note that your financial and other supports for different initiatives may also be time limited. So looking at the longer term impacts, when something is working well, is there a way that we can incorporate that into a longer term practice?
Thank you, Catherine, for those excellent insights from a health regulatory and privacy perspective. You've provided some good food for thought and great action items and risk reduction measures that could be employed. We're going to shift gears now to look at things from a labor employment perspective. Certainly, as services ramped down across the province, there was significant impact for many organizations in how they were managing their human resources in the organization. We're pleased now to be joined on the panel by our partner, Hugh Dyer, to talk about some of the implications for labor and employment as we now look to resume services in our workplaces.
Thank you, Karima. Good morning, everyone. The top three issues, if we can have the next slide, Karima. Thank you. The top three issues are: number one, dealing with and avoiding the possibility of deemed terminations under either a collective agreement or under the Employment Standards Act. It's important to note for these purposes, I'm not going to be discussing in this particular area issues relating to constructive dismissal extensively. We're going to focus on collective agreement issues and employment standards issues. The second is managing recalls, and then the third is dealing with issues that are going to arise or may arise when actually the employees start to return to work. So number one, under the Employment Standards Act, the employer and employer can temporarily lay off employees for up to 13 weeks out of 20 without continuing any payments or making other arrangements. It can also continue for not more than 35 weeks. In other words, it has to be less than 35 weeks out of 52 if the employer provides various types of payments or benefits. For example, if you continue a group insurance plan or pension payments, or if you have a sub-plan, a supplementary unemployment benefit plan, you can keep a layoff up to 35 weeks without it becoming a deemed termination. For those of you that are familiar with the Employment Standards Act, you may know that there are separate issues with respect to eligibility for severance pay. The rule for severance pay is a layoff is temporary for up to 35 weeks out of 52. You don't have to continue benefits or make payments to sustain that. The Employment Standards Act, for those of you who aren't familiar with it, is a labyrinth of rules which seem to overlap or conflict with one another to a certain degree. So it's not easy to manage your way through the Employment Standards Act, but those are the basic rules with respect to temporary layoffs. There's one other rule that you sort of need to keep in mind, which I've called the 50% rule. Under the Employment Standards Act, a layoff week is any week in which an employee doesn't receive at least 50% of his or her normal wages. So, to take for example, an employee is laid off temporarily for 12 weeks, is then recalled to work, but you're under a graduated return to work plan. Employees who is normally full-time, works 5 days a week, only works 2 days per week in the first 2 weeks after he or she is recalled. That employee would technically be entitled to his employment or her Employment Standards Act termination pay because the layoff has now exceeded the 13-week rule. So that's something to keep in mind in managing your recalls. And certainly, any plan to have a graduated return to work should keep in mind the 50% rule. Now, moving on to managing recalls, with respect to this particular aspect, having a collective agreement can be somewhat of a benefit because it usually, under most collective agreements, it will provide for a procedure for recalls. That's something that's generally lacking with respect to non-union employees. Of course, you may not like the procedure with respect to recalling union employees because you may not like the fact that you have to, in general, recall the senior qualified employee to work when you would prefer to perhaps recall someone else. But nonetheless, under a collective agreement, there will be a procedure. The procedure should generally be followed. If you don't follow the procedure, subject to what I'm going to say in a minute, you may well be exposed to damage claims for employees that ought to have been recalled. The exception is that under the Emergencies Act, the government, as you probably all know, or many of you know at least, accepted hospitals and long-term care facilities from various provisions and agreements, including collective agreements, with respect to things like layoffs and seniority rules. So while those emergency orders remain in effect, You may not have to actually comply with the layoff and seniority rules in your collective agreement, but those orders are time limited. And when I checked yesterday, the relevant orders would appear to expire on the 29th of May, which is this Friday. Now, they may be extended, but you will not necessarily be able to rely on those orders to work around the collective agreement in the long term. With respect to non-union employees, unless you have a policy or contractual provisions which deal with how you recall non-union employees, those rules exist, but they're relatively rare. There are no firm statutory or common law rules with respect to how you conduct a recall of non-union employees. The only guideline is under the Employment Standards Act that says that an employee may not be entitled to his or her termination pay if he or she doesn't return to work after being recalled for a reasonable period of time. And so you have to allow an employee a reasonable period to return to work. If he or she doesn't return to work, then he or she's not entitled to termination pay. And at that point, you probably would at least consider, not necessarily implement, but consider a termination. Now, what's reasonable obviously will depend upon the circumstances. You can't recall an employee today for a return to work tomorrow. In most circumstances, in all likelihood, the employee has some sort of legitimate reason. On the other hand, if an employee says, well, I don't want to return to work for another month because I like the warm weather and I'd like to take an extended vacation or time off, then that's maybe not a legitimate reason. And that might be a situation where you can say, well, that person's not returning to work within a reasonable period of time. The environment also has to take into account that the government during the pandemic has created various types of statutory job-protected leaves. They've created emergency leaves and infectious disease leaves of absence to protect employees who are ill or quarantined or self-isolating or who are caring for people who are ill or self-quarantined or children that are home because the schools are closed. If an employee falls into one of those categories, when you try to recall him or her, then you obviously won't be able to exercise the right to terminate because they will have a reasonable, assuming they can prove that they can fall within those categories, they will have reasonable grounds to not come back to work. But what you'll want to do is you want to confirm that those employees are now on leave and not on layoff so that you don't exceed the temporary layoff rules. And I think now we will go on. Oh, I do want to touch on one other issue here, Karima, before we go on. Recall communications. The communications may be prescribed. The content of the communications may, to a certain extent, be prescribed under collective agreement. But that's not necessarily the case. There will be certain rules that probably the collective agreement will at least provide for minimum requirements for communications. And because these collective agreements were often written many years ago, they may provide for some sort of written communication, often a registered letter or something like that. Obviously, that seems a little bit archaic in this day and age, but nonetheless, if you are going to be recalling employees, you should, in all likelihood, consider complying with at least the minimum requirements of the collective agreement, even if it seems somewhat archaic. It doesn't mean that you can't do more than that. You can call employees, you can text employees, you can email employees, but you should probably do whatever the collective agreement provides just to make sure that you complied with the strict contractual requirements. The other thing that you want to have with respect to either union or non-union employees is proof that you've actually communicated to the employee. Just because you sent an email or a text or a voicemail message doesn't necessarily mean that the employees received it. So you want to have some sort of mechanism by which you can confirm that the employee actually received it. It may seem a bit old-fashioned too, but then one of the most effective ways is to send written communications by courier with proof of delivery. In other words, require the employee to sign for the letter. And now, employment issues arising from the collective agreement, from the return to work, we're going to deal with primarily in the next section.
So there's clearly a lot of legal implications and processes and rules to be followed as organizations bring back employees into the workplace to resume in-person services. What are some immediate action items that they can take prior to service resumption?
Thank you. The first point may seem kind of obvious. If you're going to do a recall, you're going to have the employee's contact information. If you have a process that you have to follow in the collective agreement, for example, or an employment contract, I have to follow that process. So if you have to mail something, you have to have a mailing address, but you probably have all of that. The thing that's a little bit more novel in this particular situation is availability information. Do you know whether or not the employee is ill? Do you know whether or not the employee has to quarantine? Do you know whether or not the employee has school-aged children that he or she may have to take care of? Do you know whether or not they'll need some sort of adjustment to their hours of work because they have family requirements? You want to have that kind of information if you can collect it in advance, because that will help with your planning. You don't, on the other hand, want to sort of red flag for the employees and say, well, hey, maybe you can take this kind of leave of absence. I think the inquiry is, we're just updating our records. Can you provide us with your employee, or make sure that we have your contact information? And also, can you tell us whether or not you may be available to return to work within this time frame? Obviously, you don't necessarily want to pinpoint a particular time when you'll be recalling them, when you're collecting this information, but you want to give them some idea as to when they may be recalled, maybe a period of a couple of weeks or whatever, so that you can help to gather, or hope to gather, some of this availability information. The next thing is that assessing workforce requirements. Those are pretty much all practical issues to a large extent. How many you're going to need, who and when. But there are some things that you have to factor into it. When you're in particular, when you're selecting who to return or who to ask to return, you're going to have to monitor your collective agreements to make sure that you're applying those, subject to the emergency order. And also, we're going to have to make sure that for non-union employees, you're following a rational process that has some sort of objective measures in it to identify the appropriate employees. I say that because you may well be employees who were left on layoff. They may have been patient up to this point in time, expecting that they would return to work. But when they start to hear that their colleagues are going back to work and they're not, their patience may start to fray. And so you want to have, just from an employee relations perspective, at least, some sort of objective measure that you can use to respond to employee issues. And obviously service or seniority, don't really usually have a concept of seniority with respect to non-union employees, but service is an objective measure which you can point to and which would generally be acceptable. It's not the only one, but it is the one which is relatively easy to use. If you're going to use some other measures like performance, that's obviously can be an objective measure, but you have to have a robust performance management system that you can point to and that is can be validated if necessary. The other thing you have to do once you've sort of assessed who you're going to bring back on a preliminary basis is take a sober second look at the list and see if the list of people that's coming back, or in particular the list of people that's not coming back, primarily falls into a category which may be protected by the Human Rights Code. To take a very simple example, all the people that are coming back are men, and all the people that are not coming back are women. You may well have a human rights complaint on the basis of gender discrimination. It's a very simplistic example, obviously, but nonetheless, it's always wise to make sure that you take a look at your list. Doesn't mean that you have to necessarily adjust that list, because there may be perfectly good reasons for doing what you're doing. But remember that you could be challenged. Employees may be, as I said, frustrated with this situation and may be looking for an opportunity to take you to the Human Rights Tribunal, for example, with a gender-based discrimination or age-based discrimination or whatever based discrimination issue. The last thing is take this opportunity to sort of update your policies and procedures, excuse me, especially with respect to non-union employees. You're going to want to be able to point to a procedure or policy if you are challenged down the road. And if, heaven forbid, but if we have to deal with the second wave, you're going to want policies and procedures in place to have, in case you have to address that. Now, the next topic, and I mentioned this briefly under the first issue about the 3 key items, is you're going to have to perhaps address the necessary changes to terms and conditions of employment. And Catherine talked about sort of the new normal, or shifting to the new normal. When employees come back to work, you may have to vary hours of work. You may have to make shift changes. You may have to cancel or reschedule vacations. You may have to reassign employees because of changed demands or because of safety issues, which Rob is going to touch on later. For example, one of the things that some employers are considering is shift changes to stagger employees, so there's not as much overlap with the risk between employees, to hopefully cut down on transmission between employees. In the unionized environment, the question will be whether or not the collective agreement prohibits that change or the change that you're contemplating. Again, this is subject to the emergency orders, which do permit some of this, notwithstanding the provisions of collective agreements. But when the emergency order is gone, at least, you'll have to contemplate whether or not the collective agreement will permit you to do what you want to do. And if it doesn't, then will the union agree to the changes? Given that there's going to be a safety focus with respect to a lot of these changes, at least, the union may be more flexible with respect to these issues to the extent that it is relevant to employee safety. Now, in the non-union environment, there may be an employment contract that limits the changes. For example, if an employment contract in writing says that the employees will work 9 to 5, Monday to Friday, to take a simplistic example, then you may have to get the employee to agree to change that. If there's no contract that provides that sort of limitation, then you still have to be cognizant of constructive dismissal issues. Most of you no doubt know that constructive dismissal is a common law court-developed process, principle which says you can't fundamentally change the terms and conditions of an employee's employment unilaterally. And if you do, that may be entitled the employee to treat his or her employment as terminated and make a claim for severance pay, which is obviously quite expensive. Now, these employees have been on layoff. We haven't seen a flood of constructive dismissal litigation yet. Still may come. I think most employees are realized that their employers have been affected by the pandemic and they've been patient. Their patience may start to fray. And if they come back to work and they find that their job is significantly different than it was before, then that may well be the last straw. We move to the next one. Thank you, Karima. Lastly, and this is something that Catherine and Karima have already touched on to some degree, you're going to have to do some contingency planning. You can't expect that each and every one of your laid off employees will necessarily return. The pandemic's still raging. Not it's diminished, but it's still out there effectively. It's going to affect some of your employees. It's going to affect, the schools are still closed. So there are going to be parents, younger children who have childcare responsibilities. So we won't be able to expect that all will return. And Rob is going to touch on this next, but we'll also just have some employees that are frightened to return to work, and they may well refuse to return to work. Can we go back, please? We also will have employees that will be in isolation or quarantine because of it. And I think that Catherine already touched on this. There will be the possibility of the second wave, and it's probably not too early to start planning for your possible human resource adjustments if a second wave is necessary. For example, you should consider putting in a layoff provision in your employment contracts. And if you don't have employment contracts, adopt a non-union layoff policy. And I think that's it for this slide.
So we're almost out of time, but if you do maybe a quick recap for us as well, in addition to the excellent action item homework that you've given everyone that they can get on right now with their HR departments, are there any tips that you have for risk mitigation?
Sure. I can cover these fairly briefly, I think, Karina. Obviously, if you can put your employees back to work and maintain their employment, that will be the best thing to avoid the constructive dismissal risk, which is really your primary risk, especially with respect to non-union employees. Hospitals don't qualify for the wage subsidy, but other employers that are listening to this may well. Also, there is under the Employment Insurance Act, policy under which employees can work share, in other words, work a reduced work week or work in time and get EI benefits to cover some of their wage loss. There's also the possibility of supplementary unemployment benefits. Those may be not particularly relevant when the $2,000 per month Canada Emergency Response Benefit is in effect, but nonetheless, it's something that's worthwhile considering at a later date. And not too far down the road, because that benefit, the CERB benefit, expires at the end of June, at least based on current information. There may be other things which you can do to mitigate the risk of constructive dismissal issues. I think Rob's going to touch on the communications with respect to health and safety. Obviously, they're going to want to know that their employer is taking their safety into consideration when they want to come back to work, if they're going to come back to work. I think those are the principal issues I could touch on that. Prima, thank you.
Great. Thank you so much for those excellent insights, Hugh, from a labor and employment perspective as everyone grapples with how to bring their employees back into the workplace for in-person services. We're going to round off our expert panel today with our Miller Thomson resident occupational health and safety expert, Rob England. Rob, what are some key issues from an occupational health and safety perspective to consider for in-person service resumption?
Well, I'm happy to address that, although I should start by thanking all the people participating in this coffee talk for affording to us the chance to talk to you. The key issues, I think, at the moment start with the right of workers to refuse unsafe work. I say that because I deal obviously with the lawyers at the Ministry of Labor, if not every day, certainly every week. And they tell me that in the course of working on my files with them, that the Ministry of Labor's focus at the moment is dealing with the staggering number of work refusals that are out there. So it is an issue of some considerable importance. And you will know, of course, that one of the key provisions in the Occupational Health and Safety Act is that provision that deals with the right to refuse unsafe work. There are occupational restrictions, as you know, but that doesn't stop employees from asserting a right to refuse work because that will trigger a Ministry of Labor attendance. And as we're going to get into in a minute, when the Ministry of Labor attends at a workplace, they're not confined to dealing with the reasons for which they were called to the workplace in the first place. So a Ministry of Labor could show up at the workplace in order to deal with a work refusal and make a determination that the worker didn't in fact have a right to refuse unsafe work. But that said, while the Minister of Labor's inspector is there, he or she can issue orders to deal with any contravention that he or she finds in the workplace. So it's an important point to make. Just because, as I say, just because a worker may not have the right to refuse unsafe work, that does not end the matter. The second issue, and this has been a problem for some time, is the view of many that employers do not ensure that they have supervisors that are competent and knowledgeable with respect to the OSHA requirements applicable in the workplace. The Act makes clear, the Occupational Safety Act makes clear, that an employer has an obligation to hire competent supervisors to ensure that their supervisors are competent. And competent person is a defined term in the Act, and it therefore is incumbent upon an employer to ensure that those people that are supervising the work or the workplace meet that statutory test as to what constitutes competence. The other issue is the Act has reporting obligations in certain fact situations, and there are strict timelines with respect to compliance with those reporting obligations, and a failure to do so is a breach of the Act. So you want to make sure that you have someone in the workplace who obviously is familiar with those obligations and will ensure that they're discharged. Bear in mind that the times set out in the Act for reporting obligations are straight days. They're not business days or working days. The OSHA, I referred in the second slide, or the second bullet point on the slides, to OSHA requirements. Insofar as this is a COVID-19 related discussion, it's important to remember that there is the Act itself, and then there are the regulations to the Act. Some of those regulations are sector specific: construction, healthcare, industrial, etc. And then there are subject specific regulations. The law is clear that an employer under the licensing justification has to ensure that it's familiar with those regulations that are applicable to its work. It doesn't require that the employer or its supervisors have an encyclopedic knowledge of, every single regulation. I mean, nobody, I would think, on this call needs to worry about the mining regulation or the diving regulation, but you need to be mindful of the sector-specific regulation, if any, that applies to your workplace. Not every workplace in Ontario is governed by a sector-specific regulation, and then any subject-specific regulations. At the end of the day, the key employer obligations are going to be the obligation, as I say, to have a competent supervisor, to ensure that there's information, instruction, and supervision of workers on the workplace, that it's essentially done a hazard assessment and it's acquainted its workers with the hazards in the work. Sorry, we can move forward then to the next one. So, go ahead.
So based on that, there's clearly a very detailed statutory regime that some health service providers may not be as familiar with, not having previously had to address potential for work refusals in their workplace, so which will be a new concept, and you provided some really important information about that. Are there immediate action items that should be taken prior to resuming in-person services?
I think so. The first one that came to me and is in the context of trying to stay ahead of the problem. And my sense of it, I have no empirical evidence to support this, but my visceral sense is that what we're now seeing is employees that are much more inclined to make demands of the employer with respect to health and safety issues around COVID-19. And what you want to do is be communicating to them that the employer has, in fact, the kind of return to work resumption plan that Karima's been talking about, so that you can give, as Hugh said, give them confidence that the employer knows what they're doing and is doing everything reasonable to ensure their health and safety. And so to my mind, that means that you have to have a communication plan so that you can provide to your staff details with respect to the resumption to work plan and the corresponding OSHA obligations upon your supervisory and managerial staff. Remember, the Occupational Health and Safety Act, by definition, managers are supervisors. And I know this seems self-evident, but in many places, there's a failure on the part of the employer to actually have identified who the supervisors are and to ensure that those supervisors get in advance the details of the resumption of work plan and what the obligations are of not only the employer, but of the supervisors themselves. And moreover, that they're familiar with the obligations of your workers. That communication plan obviously will include the fact that the employer has or should have, as part of its resumption to work plan, reviewed its existing health and safety policies to ensure that they continue to be up to date and current in order to address OSHA obligations. So, you would have, you have a policy with respect to an issue. So, for example, you have a policy with respect to confined space entry, or you have a policy with respect to workplace harassment, and then you have a program that contains measures and procedures in order to implement the policy, and then you have training to your people. So these are all the constituent parts, frankly, of your health and safety compliance regime. If we can just keep going, Karima, the single biggest failure, I think, most employers have the policies, they have the programs, they've even done the training, but the biggest failures are the training is cursory and inadequate, and they fail to supervise to ensure that on a day-to-day basis that the policies and the programs are being implemented, right? And as we go through this process, the next slide I had, or the next bullet point, was you're going to want to think about how you're going to deal with allowing employees to continue to work remotely if those employees are reluctant to return to work. Now, Hugh dealt with that. I guess Hugh's world and mine are a bit like Venn diagrams. They overlap to some degree. But from an OSHA perspective, the issue is going to come up from time to time. You've got people working remotely. What do you do to ensure that you're meeting OSHA obligations to them when they're working out of their home? Okay. And there are real issues here because the Act actually has a section that says that it doesn't apply in a private residence. But that section was written in 1976, and it speaks about servants as opposed to workers. So you're going to want to be mindful of that because there are obviously limitations. You're not going to go and do a workplace inspection of everybody's house or ensure they've got the poster up and the railings meet the requirements of the Act, etc. But there are those issues you're going to want to think about. I'm repeating myself, but you want to make sure that you actually carry out your plan to ensure ongoing supervision of your workers to ensure compliance. And in the health and safety world, Ontario, we speak of workers, we don't speak of employees, because as you know, employer obligations under the Occupational Health and Safety Act are obligations not only to your employees in an employment law sense, but they are obligations to your dependent contractors, your independent contractors, and indeed to the employees of third parties that you've engaged for the provision of services. So it's a much broader scope of obligation. We just mindful of the time, Karima, so maybe go to the next one.
To finish us off, Rob, do you have some tips for risk mitigation that can be implemented?
Right. I do. And I apologize in advance for saying this, but record keeping is a big issue. Okay. You're gonna have clear and comprehensive training, obviously, because you've got your resumption of work plan, and you've revised your policies and programs to reflect the new normal, as I guess people are calling it. But that training, as I said earlier, you just can't give people a handout, right? It's got to be comprehensive. The test is whether or not, at the end of the day, the training you gave to your supervisors and the training that you gave to your workers is sufficient to ensure that they understand what your policies, programs, and expectations are. And you know, for some people, that's going to require delivering training in the languages of your workers, not necessarily English or French, as the case may be. And you need to keep records. Obviously, clients never keep the kind of paperwork that lawyers would like to see, because if you did, that's all you'd be doing, is making records. But you need to have records that deal with the training you've provided. And that's the records, you know, they have to be dated. They have to indicate who provided the training, when it was provided, the duration of the training. These aren't legal requirements, but they're practical requirements, because in the absence of records to prove that you're given the training, it's going to be very difficult to rebut the allegation routinely made by workers that they didn't get the training that they should have received. And that training is obviously going to be at orientation or recurrent, or in the instant case, people coming back to work are going to need to get, you know, relevant training, you know, and obviously, in my view at least, the training at this point should focus on health and safety training. How you file, you know, expense reports can wait. Okay, you need to anticipate that the Ministry of Labor may end up in your workplace. Okay, and as I said earlier, doesn't matter the reason for which they got there. Once they're there, they can consider anything they want to. So you really want to have a protocol in place to deal with the Occupational Health and Safety Act, so attendances of Ministry of Labor inspectors. And you want that to ensure that you got a prompt and effective response. If you go to the next slide, you really should, in that protocol, have a person that's tasked, or persons, with dealing with OSHA issues, because you want there to be a person, or ideally a single person, but you know, you may have shifts, so maybe it's more than one people, but you want to have a finite number of people dealing with the Ministry of Labor. Because if you got 8 people that's responding to them, you're going to have 16 different answers to their questions. And we have help for you, you know, letters or whatever, memos to help about what should be in such a protocol. But you really want to make sure that is in place so that you deal with them in a way that's appropriate. I've repeated that. I won't repeat myself with respect to the ongoing supervision, but let me, if I can, just make a number of quick further points, less than a minute and a half here. Remember, when the Ministry of Labor is there, they will undoubtedly have a checklist. Again, whatever the reason is for their attendance, they always want to see your health and safety policy, the generic one. They want to see policies, your policies and programs with respect to workplace harassment and workplace violence. Again, not saying that they may be there for an entirely unrelated issue. They're going to want to see that you've given the regulatory safety awareness training to your workers and to your supervisors. Remember, there are 2 different training modules. And a failure to have any of those things is a contravention. So if you haven't done those things, they'll issue an order or orders. And they will want to see your JHSC or minutes. They'll want to see evidence that there's been the monthly workplace inspection, because they're going to go through that checklist. So you don't want, in hockey terms, to take a cheap penalty. Make sure you've got all that stuff. It's ready to go, and you're ready to hand it over. Okay. If I can just jump back, you're going to have people who. We often have people who refuse work, and we believe that the work refusal is frivolous and it's vexatious. But go through the process. Don't take a cheap penalty. Don't lose your patience, because if you say or do anything that constitutes a reprisal, then it triggers a whole other section of the Act, and you get a reprisal, and it'll take a year to get to a hearing at the OLRB. And remember, the presumptive remedy, if there's found to be a reprisal, is reinstatement with back wages. So you don't want to be in that position. If the ministry issues to you orders, you're going to want to carefully consider whether you want to appeal or need to appeal. But you still have to comply with the order by the compliance date, even if you're going to appeal, unless you get that compliance date stayed, and you only have 30 days. Okay, so it doesn't matter how great you think your relationship is with the Ministry of Labor. If you miss the 30-day period, you are out of luck. No court, the OLRB, nobody can extend that 30-day time period. Okay, so carefully look at the orders. And if, it won't take very long to have a quick discussion about whether you should be appealing them, because if the orders are issued in the context of a possible prosecution, then you're going to want to make sure that you respond to the order in the appropriate way, so it doesn't, even if you do comply, you're doing so under statutory compulsion, and you're not being deemed to admit breaches. So that's what I had to say. If we can be of any further help, let us know. Karima?
Thank you so much, Rob. Certainly for institutions that are larger and have more sophisticated occupational health and safety regimes, this is a clear message for a review and a refresh in light of current circumstances. For those who have smaller workplaces and have perhaps not as directly had to engage with the Occupational Health and Safety Act, I think Rob's given a very clear message of the need to get up to speed with the requirements of that act very quickly, given its significant implications for your workplaces. So with the last few minutes that we have today, we've covered a lot of material from Catherine, from Hugh, and from Rob, and the various legal perspectives and foundations that are going to inform your service resumption planning. So how do you tie all of that together? Because they don't come always in these neat streams that we're talking about. They're going to show up in various aspects of the resumption plan that you will put together. One key item to flag for everyone here is that although the province will begin to open up, and hopefully we will soon see the directive number 2 that Catherine and I have spoken of, the fact that you are able to provide services does not mean that you are obliged to provide services. And it is really important that you open the doors to in-person service only once you have been able to complete a very rigorous review and planning addressing the various aspects of planning that we've highlighted for you here today. Now, when that is and how you balance your local needs is going to differ by organization. It's not going to be one size fits all across the province. You will need to look at your local circumstances related to COVID-19. This relates to the example that Catherine was sharing about different levels and stages of transmission that may be different in different areas of the province and may provide for the ability to have more or less by way of in-person services. What are the service needs of your community and how can they be met? The legal obligations that we've talked about and your readiness, your organizational readiness to meet them, especially as we hear Rob talking about the various aspects of the Occupational Health and Safety Act, as well as the general risks of operation from a regulatory perspective, but also business and liability perspective as well. 360 review that you need to take to your organizational readiness, using all of these legal tools in your toolbox to inform your plan. And what will your plan look like? Well, the on-the-ground service resumption plan is going to be much more granular in terms of the practical aspects of what will occur in order to resume services. And how you set out those aspects are going to be informed by all various legal considerations and obligations that we've talked about today. That will include how you will address your use of your facility and your space, both externally and internally within the organization, any reconfiguration of space or other work that needs to be done to meet your obligations, how you'll revisit your clinical services and the manner in which they are delivered in order to be able to meet these various requirements and to respond to the potential for work refusals or other human resource restrictions or limitations that you may have. Business process and supply chain management. Everything that we talk about from a regulatory, clinical, HR, health and safety perspective is going to inform how you run your business as a health service provider and how you ensure appropriate supply chain management for what you require in the delivery of those services. And last but certainly not least is the strong human resource component and specific policies, procedures, and processes, as Hugh has outlined, will need to be considered explicitly within your service resumption plan. Plan is not without risk. And the key in developing the plan is to ensure that you have identified risk from an enterprise perspective and that you can then effectively mitigate and manage those risks. Our focus in today's discussion has been heavily on the first element of risk, specifically around legal. We've spent a lot of time on this today, talking about the various sources of legal obligations of which you need to be aware. In that discussion, we briefly touched on some other areas, but we want to highlight them for you as also being key areas that will need to form part of your risk management planning. It is not just considering the legal considerations in a silo, but as part of a larger risk analysis exercise. That will include financial risks, implementation of your work resumption plan, addressing the various requirements that Catherine has laid out from a health regulatory perspective, bringing back employees, whether they be on a graduated return basis, or addressing new occupational health and safety requirements will all have financial implications potentially for the organization. So you also need to consider your financial ability and risks in supporting the resumption plans, and where are you going to source what you require in that regard? Are there funding that will be available? Will it be available on a continued basis? And what is the impact of the current economic circumstances on your fundraising abilities? Communications is, of course, another key risk area, and we've emphasized today because it's been raised by each one of our expert panel speakers from their respective perspectives, is the importance of clear communication, both internally and externally, of changes and expectations. And part of communications, as we talk about risk management, is also ensuring that you have a clear issues management process in place, and has been touched on by some of my colleagues, some identified points of contact. Anytime there's change, there is no doubt going to be questions that will arise and a potential for complaints that will arise. And you want to be proactive in having a very clear process of how those are being addressed so that you can have a level of consistency, efficiency, and transparency in how you're responding. And that relates to, the last point, but certainly not the least point, which is liability risk management. As we deal with this global pandemic that's impacting everyone, and those on the front lines struggle to be able to bring health services to the thousands of Ontarians that have had various procedures or access to service restricted, one looks at it from a community service perspective and trying to do the best that you can. However, there is an unfortunate reality as we look past to history, as what has happened in previous epidemics in our country and elsewhere, as well as litigation that has already to some extent commenced within the province around access to PPE in workplaces and their conduct. It's important that you consider that threat of litigation as an unfortunate reality of your resumption planning, which means ensuring legal compliance of the plan so that you can demonstrate the standard, as Catherine met, that you are meeting in what you're doing. As Rob really emphasized, monitoring and enforcing compliance with what you are establishing as the rules of your resumption plan. Contingency planning, raised across the board by all of our expert panel. Contingency planning not only for if something goes wrong, but also if we need to move back and through the various phases of this pandemic lockdown. And last but certainly not least, I leave you with the homework of insurance coverage and changes in the manner in which you're delivering services, in ensuring that you have an understanding of what your insurance cover is as you open your doors and deal with these potential issues surrounding COVID-19 in your workplace, and as well as you adopt new and different modalities of care within the virtual space. We've covered a lot of material today. What is clear is that COVID-19 continues to have a significant impact on health and social services across the globe and across Ontario. The resumption of health services will require undoubtedly rigorous preparation and planning to protect both the health and wellness of your employees, your patients, and clients, but also to protect your organization from unintended risks. Your plan should take an enterprise-wide approach to organizational readiness, and it's important that you reach that stage of readiness before you open your doors. Ultimately, each of you will need to prioritize your response and how you will proceed based on your local circumstances. We do thank all of you for joining us today. Again, if you do have any questions about anything we've covered today or require supports in your resumption planning processes, you're invited to contact any member of our panel that has been with us today. Thank you to all those who participated, and have a wonderful afternoon. Stay well.